Peace. I'm Money Green of Money Green Multimedia Group. I also go by the name Brother Sharif Al Hadi Al Bey. I'm coming to speak with you once again on the topic of sacred geometry and the law of the court magician. Previously, I spoke upon the extrapolated cube, or just a cube stretched all the way out and just laid flat. And I was explaining how the principles of Mortmain are involved, and I wanted to speak more on that subject. Now, we know that we're dealing with three forms of court. Okay? We have law, we have equity, and we have ecclesiastical. Now, law, we have what we would call the common law, and it is interwoven through all the laws that you bring up, from statutes to ordinances to trust law, contract, all of these things and the principles that surround these things are within law. When dealing with equity, we're dealing with matters of basically money. Now, you have a equitable title. In other words, that is the only way the court can actually hear a case involving you. So that is an equitable title, which gives room to trusts. So because there is an equitable title in place, there's value due to your birth certificate. The court, on its own will, by the whim of the clerk, creates what is called a constructive trust. Now, a constructive trust in a bankruptcy is basically valueless. And that's cool. That means that when you come to, when they summons you, when they do their magic and they summons and you appear, you're actually giving life beyond the grave in the bankruptcy. And so your words, they use them according to equitable principles, where there is engulfed contract language, civil language. Okay? In fact, all law is based on civil. There's no such thing as civil law. You can look at the Federal Rules of Civil Procedure, Rule 2. It tells you that there shall be one form of action, and that is the civil action. But these three forms of court go under these civil principles, so they operate under contracts and things of that nature, non-violent principles. So while you have law and you have equity, your commerce, your admiralty jurisdiction. By the way, they call us vessels in the United States codes. You can look that up in Title 28. Just Google it. Do Title 28 and then put vessel. And then, you can look at the vessel description. They call us vessels because we're operating in maritime. There's no secret. So all the way up the ladder, it's maritime, or it's in commerce, or the sea of commerce. Hence, the Holy See, bringing in the ecclesiastic concept of the form of court. Now, each form of court operates in such an illegal manner, by the way, because while there are three forms of court, there shall be three forms of court, but they made it only one form. So they mixed an estate in with ecclesiastic trust with law, when these are three different forms. So you mixed it all into one, but the spirit of it all is still the same. So you manipulate it under whatever form you want to. Because certain words, certain terms you use in law, they actually open up doors and avenues to other forms of law or forms of court. And yes, these principles do come out of the Bible. I have a great example for you. Because I'm a uniform commercial code phenomenon with that thing. I've done a lot of things with it, understand it clearly, and I'm not the only one. Of course, I learned from others, and I also learned from the books. What I'm going to explain here are the three forms of court example used in one. So I'll show you what I have here so you can see it. It deals with the 3 forms of court, right? And the way to control the 3 forms of court, it always has to be through technical procedure. And they know this, but they don't, because they know you don't know this. Okay? So there's some strategies in place that will allow you to prevent them from adjudicating or finding an order or issuing for the judge to just boom, I ordered this, for them to adjudicate. All right, and in order for them to prevent them from adjudicating, you have to know some technical procedures. Okay, now these technical procedures will not put you in dishonor with the court because they are woven into the law. I'll show you. So the rules, or the canons, all right, they are called your rules of professional conduct. Okay, now your rules of professional conduct always have these particular procedures in place that the lawyer or the judge, whom are the same people in law and in equity, that allows them to be in position and hold a code of ethics that they can't violate. Okay, and these are controlled by the ecclesiastical side. That's why they're called canons. And by the way, canon means priest or priestly law. Hence, they wear the black robes. So your technical procedure, all right, your first issue, because we know that the straw man is fake. Therefore, there can be no real claim against you. Okay? So what we'll do is we'll use Rules of Professional Conduct, Rule 3.6 in New Jersey. I'm familiar with New Jersey right off the top of the head because I used to live in New Jersey. I'm familiar with New Jersey. That Rule 3.6 says that it is against the law for them to advance frivolous claims. So, if there's a frivolous claim in place, then you know that they had to drop the case. So the question is, how can any case that I am working in become frivolous? How can I point it out? Well, there are many different ways that you can point out that the case is frivolous. You have interrogatories. Like the root word for interrogation comes from this particular word, interrogatory. Interrogatory, under Federal Rules of Civil Procedure, Rule 33. They allow you to ask questions under an affidavit. The questions that you ask are relevant to discovery in the case. You file it and inform all courts. I don't care if it's child support. I don't care if it's municipal court. I don't care, whatever it is. You file that, and the interrogatories ask simple questions. 1, do you have a claim against me? Addressing the particular individual, you may have judge such and such. Remember, the judge is never the one that's issuing the claim. He's the referee. But because everything is mixed up and he has an oath on the court that he has to uphold the court. In fact, all of them swear that. You can look at something called Corpus Juris Secundum, which means second body of law. Look up Title 7, Section 4. And it tells you that his first obligation is to the court, his second obligation is to his client, and whenever there's a conflict, the first obligation always supersedes. In brief, in short, it summarizes that. So if you look at that, you see that they all work for the same thing. Now, under law, that's a conflict of interest, but remember, you're not trying to cause controversy. Because if you say that's conflict of interest, then there's controversy. You know, the 7th Amendment says that any case or suit and controversy which shall exceed $20. Well, you heard it's not $20, it's the word controversy. Okay? So you don't give them no controversy. So what you do is the interrogatories. The interrogatories based on the affidavit is used as evidence on the record against you or for you. So you ask, who has a claim against me? Claims come from contracts. A breach of contract leads to a claim. A contract comes from an agreement. Now, an agreement in law is defined as a meeting of the minds way before it is even on paperwork. So we are in agreement way before I sign anything. So this is a meeting of the minds. All right? Now bear that in mind because this is important. So because there's no agreement that you know of, yet there's a contract which implies a claim. Now they don't have a claim; they have charges. So they'll say, "Yeah, the state has a claim against you." Okay, fine. You can create the controversy here at this point now because this man just lied to you. And here's where you can get him to lose his case right here at this point. He knows the difference between a claim and a charge. He does. You see, so when you say, do you have a claim against me? The state has a claim. Sir, you know the difference, or ma'am, you know the difference between a claim and a charge. This is barratry. Okay. Barratry is the act of advancing a frivolous cause. This, we go back to the Canaan rules, remember? 3.6. They cannot advance frivolous claim. So once you say that, he'll say, But me, I like to just hit him with what the terms say. Hit him with the terms say in the book because remember, there's a lady doing like this or a man doing like this. Somebody's recording. So I'll say you're advancing a frivolous claim in violation of rules of professional conduct, Rule 3.6. Did that to this guy in court, man. One of the lawyers. He was writing stuff down because it's all scripted. If you go in there and pay attention to what's going on, please. When one side is talking, they're writing it down what you're saying. When the other side is talking, they're writing it down. Pay attention because it's all scripted. And they know the words to use, what words did they address, how do I have to address it, just pay attention, right? So that shows a frivolous claim. Once you state that on the record, he's going to get ready to haul ass. So the judge is almost guaranteed, not almost, he's guaranteedly going to save him because he's going to open up what they have called windows. Because now, remember that law said, Corpus Juris Secundum 7, Section 4. It says that whenever they're in trouble, they got to have each other's back. Now, this guy is in trouble, okay? So the judge will jump in and try to rescue him. Okay, there's no frivolous claim. Why don't you file that with the people? No, because I just filed it on the record right in front of all of you. So I have to no longer inform you or use any paperwork because the paperwork enters the land of the dead. It's a negotiable instrument and it... Okay. The paperwork is a negotiable instrument because it has words on it. The Uniform Commercial Code, UCC 4, deals with letters of credit. So what your words are letters spoken of credit. In fact, that's what commerce means. It means communication. It means transfer through communication. So when you speak these words, they take them apart and find the money in them. And they'll put them on, and now this is valuable. So I use my words and how I use them on that record in light of how we use them. But I just jumped from law to UCC. Did you see that? Because I'm only dealing with what they call the law, the canons. This is the priesthood. So what happens is because now I didn't establish a non-controversy, because there's no controversy here. There is no claim here. I said, where is it at? You didn't show it, so now I'm not going to even argue. That's barratry. I'm going to report you to the Supreme Court of whatever state I'm from and to the Bar Association of whatever state I'm from to have disbarment procedures commenced. Why? Because you are committing a crime. This is fraud. And when the judge jumps in and don't stop him and throw it out at that point and don't recuse himself, because he has to recuse himself in order for him to not be held accountable. Remember what Pilate did? He washed his hands of it and walked away. He has to recuse himself. If he jumps in and saves the prosecuting attorney in this matter, this is called collusion. And this is a crime. So now you're setting a trap for them. Because now not only is it collusion, you're stopping them from being able to go to trial. So now law is out of the way. You kick their ass in law, but they have an advocacy for the state of New Jersey, which brings in a trust. Because see, anybody that went to law